So, it was some email where you're complaining about not having names of police members, is that right?
Police member, yes, that's right.
Alright, well, let's find the email.
1st of March from Ms. Anaz to Mr. Oni.
I don't even know which tab the emails are in.
It'll be tab 19, Your Honor, but they appear to be bundles relating to different time frames because they're emails with different people.
May I send an electronic copy of the email to everybody to help?
Is it alleged that it's in the VicPol member bundle, Your Honor?
I don't.
What one is that?
I don't know. That's what I'm referring to as tab 19, but is it maybe to the Legal Services Board? I don't know if it could be.
What date, Mr. Cooksall?
1st of March 2022.
1st of March, but I don't know what he's talking about.
Are they in chronological order?
No.
Date order?
That's what I'm saying. Because they're in chronological order between the parties. It's not a total chronological order, if you understand what I mean. Because between members, that's on its own. Between Oni and certain people, that's in their own chronological order.
Oh well, cannot be that hard to find.
Still searching, Your Honor.
That's all right.
It's a large document. Your Honor, for instance, page 436, bundle 19. That's the first page.
Yeah.
You see, the name of the VGSO person has also been redacted.
Why do you need that?
How do I?
All right, focus on that. Why do you need it?
Okay, so recently it was disclosed to me that Ms. Carol Orphanos, the VGSO person in charge of running the prosecution, first got involved in these matters when I had first.
Not the person running the prosecution.
Sorry.
She is not in charge of running the prosecution.
She is, they told me on email.
The Director of Public Prosecutions is in charge of running the prosecution, Mr. Cooksall.
Well, that's arguable because
it's not arguable.
She's still responsible for the disclosure of material. She's part of the prosecution by the definition under common law. In any event, she was exclusively in charge until the filing was made.
Well, right, why do you need this?
Yeah.
What's the problem?
I was advising the court why I needed the names. She first became involved in the matter when Victoria Police was prosecuting the matter independently of VGSO as Victoria Police's counsel.
They would have still been. But you've elected to go to trial.
No. They changed because I overheard Mr. Albor's conversation and then Victoria Police had a conflict, so the VGSO had to be made in charge of running the prosecution. The VGSO were also managing the police's defense in my foreshadowed unlawful arrest tort law case against them. Ms. Orphanos was the defense lawyer and then she took over the prosecution.
This is why after that, this is my...
That's not the point. The point is that I only discovered that because her name was visible in other correspondence. I cannot pick up things like that if the names of government officials are blacked out. And there's no reason why they should be blacked out. Your Honor doesn't even have a discretion in the matter according to Brazel v. State of Victoria. Miss Gleeson finds that amusing. But that is the law. And frustrating, she mumbled.
Your Honor, if you look at the email itself, it is just.
That's not the point.
It is exactly the point.
There's other correspondence.
No, Mr. Cooksall, please.
The email itself simply directs people to notify a person at the VGSO when materials have been disclosed.
Yeah, I agree.
That doesn't matter.
But the point Mr. Cooksall is making is why is there a need for those names to be redacted?
That's right.
Because she's not a party to the proceedings at all. She's a lawyer. Or is she? I don't even know who it is.
No.
I haven't seen it unredacted. Well, again, we go into the realms of supposition here. It is a person they have been told to contact at the VGSO to confirm documents disclosed.
Well, one more reason why.
Why is it redacted though?
Purely, I believe, I would imagine, and again, I'm now going into the realms of supposition, for the very reasons that Your Honor has already stated.
To improperly stop me from enforcing my statutory rights.
People that upset Mr. Cooksall will tend to be added or threaten to be added to proceedings.
Yes, absolutely, and there's nothing improper about that.
All right.
This court, Your Honor, is not hearing a vexatious litigant application.
I order that their names be displayed.
Thank you, Your Honor.
All right. Any other difficulties?
Yes, Your Honor. So, for instance, the reason why I had asked for the CCTV footage of the area where I was held in prison is because there was a police officer who had called Victoria Legal Aid for me and then Sergeant Joel.
Where were you?
At the police station. So, what happened is I was arrested and they didn't let me contact my lawyer for several hours. For like 4 or 5 hours.
I am surprised you wanted a lawyer, Mr. Cooksall.
Well, sometimes I am capable of surprising the court. 4 or 5 hours, and then I kept banging on the door to basically make everybody know that they were acting unlawfully. One of the officers who had started his shift came to me and he said,
How were they acting unlawfully?
by denying me my right to contact a lawyer.
All right.
It's still a right even afforded to people who the police hate, and a person who was starting their shift. He walked up to me and he asked me why I was upset. I told him why I was upset. He then immediately brought a cordless phone, called Victoria Legal Aid for me because he didn't have my lawyer's number. And Sergeant Joel Caswell, who was in charge of my custody, called him aside, snatched the cordless phone from him, and hung up. I could see this through the window of the door on the cell that I was in. And he basically said that Oni had said that I cannot speak with a lawyer until Oni says so. This was confirmed to me later. I needed that.
Yeah, there might have been good reasons for that, and there may be.
And there may be corrupt, horrible, despicable reasons for that.
It's all matters you could.
And that's why I needed the CCTV footage to prove that this has happened.
Have you not been provided with?
That part has been taken out of it.
What part?
The part where the officer. I've only been given with
anything of the CCTV footage.
Yes, it's incomplete. They have no idea it's the informant.
That's fine.
Yes, I do.
Sorry, Your Honor, just disgraceful.
Your behavior is disgraceful.
Your conduct is notwithstanding my request for you to moderate your behavior. Consistently rude and disrespectful, and I ask you.
Disrespectful to whom?
Your behavior.
Your Honor, that's disrespectful.
If I can take one step back and address, Your Honor. In relation to the metadata?
Yes.
My instructors managed to get on to the informant. He's on leave, is not in the city and not in a position, certainly to attend court, but he has sent a text message. I cannot give any evidence about the metadata. I didn't take any of the photographs and I was not present.
That is the footage?
The question was directly asked. Can you give evidence about the metadata on the 6th of January video? And that's his response.
Yes, but he's in charge of the investigation.
Yes, he is in charge of the investigation, Your Honor. Again.
If not him, then who?
He will have to give that evidence. And again, it would come back to.
No.
What's appropriate for questioning in a committal?
He's already said he has no idea about that. How can I cross-examine him about that? That's what he's going to say.
Well, you can.
No, that's what he's going to say.
Perhaps think about that, because there are plenty of ways you can do it.
No, I can't. I really can't. If he says that I didn't take the video, I don't know what you're talking about. This is what was given to me. What do I do from there? How do I get the original video?
I'm not going to give you advice, Mr. Cooksall.
Yes, but you're required to give me to make sure that they comply with the order. They have admittedly they know, Your Honor.
They have.
They never said that. In fact, he himself said. Mr. Oni himself said that he cannot guarantee the integrity of the metadata given because he was not there and he can't give evidence about it. That's what the SMS said.
It's a long bow to say that he can't guarantee the metadata. As Your Honor rightly pointed out.
He said he cannot give any evidence about that.
It speaks for itself.
Yes, he said he can't give evidence.
If I can just take Your Honor to item 14.
She's changing the subject.
Yes.
That CCTV footage disclosed on the
No.
27th of October via USB.
No.
My item 14's got nothing in it.
I beg your pardon. It's on the front of the folder 1.
Okay, yeah, okay.
Item 14, CCTV footage of cells in custody on the day Mr. Cooksall was in attendance. Disclosed on 27th of October via USB at Mr. Cooksall's home address.
No.
And again, on the 28th of November.
That's not when I got it.
Via evidence now to be agitating this on the 20th of December, with respect to Your Honor, it comes back to the order Your Honor made.
The 28th of November, she said. 29th of November was the last hearing. I didn't get any opportunity to address it at the last hearing. I hadn't even, by the way, seen it because it was given to me late on the 28th of November.
Terrible when you get things late the day before.
Absolutely, and especially when you're being tried unlawfully in front of an indifferent court.
But 3 weeks plus.
Your Honor, the 29th of November, she just discussed. And the next hearing date is the 20th of December.
Been that time. It's never been raised.
What the hell is she talking about? I have no idea. Who should I raise it to? I've already written to the informant and said that it's not been provided.
Well, there's now an allegation that's been somehow tampered with or documented.
No.
Or incomplete.
No, what Mr. Cooksall is saying is that it seems, and all he can do is suppose that what he has been provided with is not the original footage, but a duplicate of the footage.
Isn't that the duplicate allegation being made about what was taken at the home? The metadata, we're talking about the CCTV.
He says it's the cell. CCTV.
Yeah, exactly.
No, not at. Your Honor, they have admittedly provided me with the footage only of the night, not of the hours that I require. So, they have admitted that they've only provided me the footage from the night I was there, not the day period when the useful events happened. So, they've not provided me with the complete footage.
So, how long were you in the cells for?
Several hours, but they have provided footage.
Several hours of you sitting in a police cell.
During the active hours, there was a lot happening. I spoke with a number of police officers. As I said, one person passed me a phone which was then snatched from his hand by a sergeant. That's what I wanted the footage for. That part has not been provided to me. And they've provided to me a part that has nothing happening.
How many hours have been provided, Mr. Cooksall?
It doesn't matter. I don't need those hours. I need the daytime hours when I was there.
Maybe it doesn't exist. I don't know.
How can it not exist? The same camera was not working for several hours when incriminating stuff was caught.
You'd be surprised how often that happens with police cameras.
Well, I'm surprised at Your Honor's awareness of how malfunctions in police devices occur.
All right, well.
And who's giving evidence about a video that was captured at my home? Because the informant has made it clear that he can't give any evidence about that.
Well, who took the footage?
Ms. Burke.
Ms. Burke, you can ask her.
No. Is she admitting that Ms. Burke did? That's my suspicion.
Oh, yeah? Again.
She is a witness at the committal, you can ask her about it.
Well, Your Honor, no, but that's only my suspicion. If it's not her, then who do I question? If she says the same thing that Oni says.
Mr. Cooksall.
There's procedures and they are not being followed here.
There are procedures which you may adopt if if you were committed to stand trial, that you could pursue that under Section 198B of the Criminal Procedure Act.
Now, Your Honor is providing legal advice.
Well, you're asking.
No, I'm asking for why they didn't comply with the court's order, and it's
just a legal mechanism. Okay, sometimes things arise at committal and then you.
But I would like the order. Sorry, I just want the court to enforce its order. I want the court to make sure.
I have.
But I have.
Look, I don't know what you want the court to do.
I'm complaining that they've given me a duplicate file. May I would like to do it from the witness box and give evidence about it. It's not going to take more than 5 minutes.
No.
Why am I not allowed to give evidence about it?
Because you can't give evidence about it.
Why? I received the file. I'm giving evidence about what I received.
I don't dispute that's what you received.
So, then, Your Honor, the video captures the execution of the search warrant. Execution of the search warrant. Police officers taking stuff from my house. The search warrant, it's an admitted fact. An agreed fact was only executed on the 6th of January, not on the 6th and 7th.
Yes.
So, how can the execution of the search warrant be captured on the 7th of January? It cannot.
Well, Mr. Cooksall, you've received the explanation.
No, I haven't.
I can't give you an explanation. That will be your evidence. No one is disputing that's the case. No one in this courtroom is saying so.
Then they have not complied with the court's order.
No, the situation is, that's not necessary. They've compiled. There may be other explanations for it.
None of that has been.
This issue, I'm not hearing anything more about it.
So, what is the resolution? What's the order, and what are the reasons for the order?
There is no order.
I have made a complaint. Are you dismissing my complaint? I am making a complaint.
I understand you've made that complaint.
And what's the court's order?
Repeatedly.
And what's the resolution?
Well, there is no resolution. I cannot take the matter any further.
Can the commissioner be asked why it was not provided?
You ask witnesses about that?
He's not a witness and he's the one who's produced it.
No, look, you have been provided with the metadata. You say that's not. What is the reason the data is the following day?
But the court accepts my.
We don't know why.
The court accepts my.
We don't know why that's the case. So, that just sometimes happens in cases, Mr. Cooksall. Sometimes things don't make sense. And sometimes you pursue that in cross-examination at a committal. That's what a committal's for.
But the commissioner has provided this to me. He's not a witness. How do I question the commissioner for what he has provided?
Well, because you've been provided with what you're being provided with.
By the commissioner?
Yes.
So, how can I hold someone else accountable for what the commissioner provides me?
No one's. Look, I can't take it any further, Mr. Cooksall.
Well, Your Honor can order the commissioner to provide an explanation.
No, I can't. Okay, where's my power to do that?
It's under the compliance with the subpoena, Section 143 and Section 144.
They say they have complied.
They haven't said that. That's a factual matter. They have to say that on affidavit. That can't be said from the. This is just a matter of law. No, this is a separate matter. This is a matter of whether or not a subpoena was complied with or there has been contempt of court. I'm alleging that there's been a contempt of court. Your Honor can dismiss my allegation.
I dismiss it.
Thank you.
Ms. Gleeson, can I ask you to make some inquiries of your... In the absence of the informant being available today, I don't know what can be done about this, but if you can make some inquiries and advise Mr. Cooksall, if it's at all possible. Why the date on the metadata is the 7th of, what is it?
7th of January.
January.
The following day.
And not the 6th?
And whether the video that was provided to me is the original.
Mr. Cooksall, there is no explanation that can be given other than that there is some fault with the device.
Yeah, and if that's said on affidavit, it will be something.
It might be that the person who took the footage can't explain it.
Well, they have to say that I'm the person. Who said they took the footage?
They don't have to. They've provided you with what they've provided you with. They say.
Who has? Your Honor, it's a nameless person. No one's even confirmed who took the video.
Those inquiries will be made, Your Honor, and the information will be provided.
No, Your Honor. The ownership details of the devices was asked and it was provided for everything else except for that video. It was provided for some 480 photographs, but it was not provided for that video.
Why is that, Ms. Gleeson?
I don't know.
That seems eminently reasonable to me. That someone had a search warrant executed at their house, and a video is taken of the execution of that warrant for a reason.
I am simply saying, Your Honor, that the inquiry will be made if the person is discovered. I can't believe that the person wouldn't be discoverable because of the very fact that these things are logged on any search warrant execution.
Well, they're not, Your Honor.
If an explanation can be provided, it will be provided.
It can be provided.
If it can be provided, it will be provided.
All right, well, that's all I can do, Mr. Cooksall.
All right, and, Your Honor, the other matter to confirm, Your Honor has ordered them to unredact the name of the VGSO solicitors in the correspondence in the Victoria Police correspondence.
That will also be done. That page will be.
Not that page, not just that page, that communication bundle.
No, that's the order that's been made.
No, it wasn't, just for that page, Your Honor. It was for that communication bundle where the name of the VGSO solicitor appears in correspondence. As it's redacted like this. There are other pages just like this.
I can't see how it makes a difference.
But Your Honor, the fact is that they can't redact it is the point. And Your Honor has already ruled on this. Why would the ruling?
I have not made any ruling on this.
Your Honor, you did.
I said I couldn't see any reason why police names needed to be redacted.
And then you directed them.
At the Victorian Government Solicitor's Office. I can't see any reason for those to be disclosed.
Well, Your Honor, it's the law. Brazel v. State of Victoria. All government officials unless there is.
Tell me where it says that in Brazel v. State of Victoria.
Okay.
Do you have a copy of it?
I will bring it up. Give me the paragraph Brazel v. State of Victoria, the redaction.
BRA to ZEL thanks. It's alright, I think I've got it. Number 1. Do you agree that it's the law that government officials, the names,
No.
of any government official must be?
Not without.
It has not been my experience.
Not without going back onto Brazel and reading it in fine detail.
No.
I don't believe that's an authority for that at all.
Again, I will point to the specific paragraph. Just give me 5 minutes.
All right, thank you.
Okay, paragraph 20.
State of Victoria and Brazel, or
Victoria v. Brazel, 2008, VSCA 37.
Yes, I've got it here in front of me.
Yeah, so, it's first referred to in the paragraph. The subject is first referred to in paragraph 21.
21.
That's where the discussion is near commencement. And thereafter it goes on and discusses that issue.
It doesn't. It talks about disclosure of PII claims.
Yes, so, there was a PII claim over the names of the people involved.
Yes.
Yes, that's what they're doing. Because otherwise, if it's
general privacy.
Well, Your Honor, you can't redact. It's not private information because they're part of the. In fact, it was said in Brazel itself there were names of non-government witnesses that were being redacted and non-government and their financial.
What else do you want to take me to? That's authority for the proposition that it would be illegal for any government official.
Okay, paragraph, I'm going to read this. We wish to say something, finally.
What paragraph?
Paragraph 59. We wish to say something, finally, about the deletion of names from the parts of the documents ordered to be released. We noted earlier His Honour's view that there was a sound basis for the claim of immunity concerning the identities of persons involved in the review or interviewed about the incident and related matters apart from Mr. Brazel and those persons involved in the attack on him. There is no cross-appeal on this point, but we feel bound to express, with respect, some skepticism as to whether any proper basis was or could have been made for the concealment of the names. Concealment of a person's identity could only be justified, in our view, if a clear case was made that the identification of that person as having made a particular comment or provided particular information in the course of the review or investigation of the incident would expose the person to danger. It is perhaps unsurprising that the state did not attempt to make out any such case to take the reenactment anyway. It goes on. Basically, what it says is that they have to have a basis.
I do not accept that case is authority for the proposition that you're contending at all.
Okay, so, what I'm saying is that they should not redact.
That's not what it says.
Okay.
A. It's obiter, anyway.
So, what, Your Honour?
B. It doesn't say that. It's talking about a particular situation in that case.
And the situation is the redaction of the names.
Yeah, in that case, it's not expressing a general proposition that names of government officials must always be disclosed. It's not saying that.
So, they have not made any application or provided any explanation.
Well,
for the redaction of the name.
Firstly, that it's irrelevant. I would have thought.
How is it irrelevant who was working on my case?
How is it relevant?
It's relevant because if they have statutory obligations to me.
No, they don't.
Yes, under the Director of Public Prosecutions Act. Every person working.
You're talking about the people whose names have been redacted, or are you talking Abu?
Yeah, in May, this person was responsible for the disclosure of material to me that's covered under the Criminal Procedure Act. What they're saying is that whatever is being disclosed to Mr. Cookshall, this person is answerable for that. Keep that person updated of what you're disclosing.
Well, I'm not going to order every single person's name be disclosed.
Okay, so this person's name then should be disclosed from all the pages. This person is clearly responsible for.
What person?
The person whose name is redacted.
What page are you talking about?
This, page 1 or page 436. However, tab 19, page 1 or page 436 of the larger bundle. Let's have just this person's name unredacted then. She is clearly responsible for the disclosure of material.
You've got the material. What's the problem?
No, I haven't. I've complained about a number of things. She is the person responsible for the disclosure of that material.
What's the problem?
She's answerable to me under the Criminal Procedure Act and under common law. That's the relevance.
No, sit down. This is just time wasting. Pointless.
Okay, so are you taking back your previous direction that her name be unredacted?
You know, Mr. Cookshall? Yes, I am.
You're taking back your previous ruling that her name be unredacted?
Yes, I am.
Okay, thank you. I don't think the court has the power to take back its ruling, but that's fine.
Well, I just did.